Cerato.
Hello, my name is Amy Cerato, and I'm a resident of Norman, Oklahoma, and also an impacted homeowner along the proposed Southern Extension Turnpike. I moved to Oklahoma in 2004 and bought my house in rural East Norman because I wanted to live in the peace and quiet and acreage affords and raise my family where we could be immersed in nature right at our doorstep. I did a lot of research before I bought my forever home, and East Norman appealed to me because the city of Norman promised in long-range documents to protect East Norman from development at all costs. The Norman 2025 Land Use and Transportation Plan, adopted in 2004, specifically recognized that it is important for the city to control the quality and location of growth, to discourage sprawl, protect water quality, and maintain the 10-acre minimum lot size in East Norman. There were no turnpikes or highways in that plan. In fact, the city of Norman had just defeated the Turnpike Plan through East Norman in 1999 with the failure of House Bill 1459 and Senate Bill 371. Those bills tried to amend Statute 69, Section 1705, to include in the vicinity of Purcell, but they failed. The bills never made it out of committee. And believe it or not, I reviewed all those documents before I purchased my house. There were no authorized turnpikes or proposed highways anywhere near me in 2004. The Turnpike Authority gave up their authorization to build the Tri-City and the East-West Connector when they didn't build it in 1989 under the one bond indenture clause, and they never had authorization to build a southern extension through East Norman. Nearly 20 years later, they still don't. They tried to get authorization in 1999, but they failed. So they have no legal authorization to build the Tri-City Connector, the East-West Connector, or the Southern Extension, and they should not be given the bond approval to destroy our homes and the environment. In fact, I think they should be sanctioned for knowing full and well they didn't and still don't have authorization to build, yet continue with the engineering design and right-of-way work, including buying properties along the routes. Not only should the bond sale be stopped, but the OTA must be forced to stop all engineering design and field work that negatively impacts the peace of mind and well-being of these homeowners currently threatened. If the courts don't force the OTA to stop work, they will continue to terrorize the public and destroy families and lives along the way. They are trying to get so far along the route, the proverbial route, that no one will stop them. The state told the OTA they didn't have authorization to build in 1989, and then again denied authorization in 1999. What part of no doesn't the OTA understand? Thousands of citizens like me are being bullied and held hostage by a deceitful state agency that refuses to follow the law and thinks they can build wherever they want, whenever they want. The OTA stays billions of dollars in debt and builds roadways that don't have to make any engineering sense or generate any revenue, because they legislated themselves permission to cross-pledge back in the 1950s, meaning that, for example, their anchor turnpike, the Turner, could pay for other turnpikes that don't generate enough money to pay for their maintenance. So as a practicing civil engineer, I will tell you that these proposed routes have nothing whatsoever to do with sound engineering practices. Not only are they not legislatively authorized, which has been shown numerous times by the attorneys in the room, but they are not in the least bit justified. Using overinflated traffic counts and congestion on I-35 to justify building these East Norman turnpikes is bogus. Their traffic projections are wrong. They were wrong in the 90s when they tried to jam it through Norman, and they're wrong again. Not only are they not authorized or justified with sound engineering practices, but these turnpikes are devastating to the environment, to the wildlife, to our drinking water, to our rare geologic formations bearing our state rock, the Barite Rose, to our ecology, and to the citizens. These turnpikes are the most destructive in Oklahoma's history, slated to destroy more than 600 homes and displace thousands of people in a real estate market that can't support comparable properties on top of a tumultuous economic environment where interest rates continue to rise. The turnpike will destroy 15 homes per mile. Just so you know, in comparison, the Kilpatrick Turnpike, built 20 years ago, destroyed less than 1 home per mile. The OTA has lied to the public at every turn, trying to placate us by telling us that the routes aren't final, and this is a 15-year build. First of all, engineering firms have told me that the routes are final, and they are simply designing the roadway and bridges within that final route path. In fact, surveying and geotechnical investigations have all but finished on the east-west connector, and properties have been purchased. Second of all, if this is a 15-year project, why the rush to get all the engineering done by October 1st and start property acquisitions in January 2023 on a project that isn't even legislatively authorized? That would be less than 1 year from public announcement to eminent domain seizures. Would that accelerated timeline be to avoid the next legislative session that could potentially pass bills to limit the OTA's authority and put citizen protections in place? Why are we rushing to sell the bonds now? What's the hurry? They haven't even done one environmental or one impact study on these proposed routes. All they send us through open record requests that take 30 or more days to get are reports from the 1980s and 90s where they had a different route that they studied within a few miles. Where are the current studies? Engineers should not engage in reverse engineering by picking a route first and then making up studies to say what they need them to say. By their own admission, the OTA justifies their authority to build anything they want by a statute that says they can build anything they deem feasible. But they have not identified these routes to be feasible. They haven't done any studies. But understand that these turnpikes have nothing to do with traffic engineering or relieving overstated and inflated congestion, but everything to do with money and development, by providing a way for the developers to push high-density housing and commercial zoning in East Norman. These turnpikes will never pay for themselves, just like 8 of the 11 other turnpikes they've built in the past 60 years. But it doesn't matter because they've legislated themselves the cross-pledging and allow their 3 money-making turnpikes to pay for the rest of the destructive and relatively poorly used boondoggle, all while swindling the Oklahoma citizens in perpetuity. The proposed turnpikes are unnecessary, they don't make any engineering sense, and they're completely unjustified, and they'll forever destroy what makes Norman such a special place to live. So, how can the Oklahoma Turnpike Authority continue to be allowed to build these unauthorized projects, which actually includes the recently built Kickapoo Turnpike? How can they be allowed to sell bonds for projects that the legislators refuse to authorize? How can they be allowed to move forward without any proper engineering justification or human impact studies, environmental assessments, or alternative build options? How can they continue to build unjustified and poorly used turnpikes that don't generate enough revenue to sustain the maintenance over time? The OTA has to be held accountable to the citizens. We must be allowed to continue our lawsuit in district court so that the citizens' voices and meritorious lawsuits can be heard and adjudicated. I am respectfully asking the Oklahoma State Supreme Court to deny the OTA permission to sell bonds for the Access program. These 3 destructive, unjustified, and legislatively unauthorized new alignment turnpikes must be dropped from the Access program before the bonds can be sold, and the OTA must be prohibited from ever bringing them up again. Thank you.
Thank you, Ms. Cerato. If anyone was unable to sign up to speak and would like to speak now, the court would recognize